Searching for guidance on brand protection? Meet JJ Lee, founder and trademark lawyer, law firm PLLC in Ann Arbor, Michigan, with over 15 years of experience and more than 7,000 trademarks registered. JJ specializes in helping entrepreneurs safeguard their brands. Tune in for expert insights on trademark law and practical tips for securing your business's identity. This is one of those things that I find interesting because it's far more important than most business owners realize until sometimes it's too late. That's been my personal experience. So I don't know what your experience is, but it's kind of one of those hidden values in a company, right? Like,
well, yeah, people don't go to attorneys until they need help, right?
Right. It's like too late. Like, oh, shoot.
Right, exactly.
I've been using that for years and years, and now somebody else wants to use it. Now we're going to argue about like who owns it, right?
Right. Exactly.
So how did you get into this? I mean, it's kind of an interesting area. I find it fascinating once I kind of learned about it, like what it's all about. But what kind of spurred your interest in trademark law? Or have you always just liked this stuff? You buy Coca-Cola years ago or something?
No. Actually, I started out in bankruptcy.
You started out in bankruptcy?
Yeah, I did.
Oh, my goodness.
So the story that I have is I realized I had to go when I was doing an intake for one of my clients, and I was inputting that, and the client was sitting across the desk. And as I was doing the inputting, the client was literally clipping his toenails on the other side of the desk as I was doing the input. And I'm thinking, I'm in the wrong industry. Why am I here doing this while this guy is clipping his toenails? So I found another work. We did, a friend of mine brought me into that business, and they did LLC and corporation filings, and on the side, they did trademark filings as well. But along the process, we didn't do any legal work. We just kind of had to manage some of the. We just wanted to make sure everything was aligned. And what we found is that this company was also filing trademark applications. The thing about trademark applications is as soon as you file it, you do get a serial number, but the USPTO won't examine it for about 6 months. And so about 6 months later, after the applications were filed, then they issue what is called an office action, which lets the applicant know there's something wrong with the application. All these applications were receiving office actions, but because we were not offering legal services, there's nothing we could do, and so we had to refer them to outside attorney or outside counsel. Then another colleague of mine, we decided, well, why not create a law firm to help these people? Right. And that's how our law firm got born. But it was really out of a necessity of I felt bad that this company was just filing applications without further guidance and legal guidance along the way, because it is a long process. Right. It is a legal documentations. It is a legal filing. So we wanted to make sure that as a law firm specializing in trademark law, we were addressing and helping these people out. So
you're a lawyer, so you're always a law firm. You just weren't doing that particular area of the law. Is that my understanding? Or then you created the law. Is this a separate law firm that you created? Is that what happened?
It's a separate law firm that we created, but the company that I was working for, they were only hiring JD for the purposes of the JD background and experience.
Oh, but they were not a law firm.
Correct. That's exactly right.
I got you. Okay, so then you broke off, have an actual law firm to do all of this, which is fascinating to me. And I think the first time I really got involved in it when we started our nonprofit, we started using terms, and as we go out there and start to serve the community, so to speak, what we found out was that other people like to copy you, which is kind of like to some degree okay, but to a certain degree not okay, because they're going to start taking away your value. And we pretty early on realized that we needed to do it. And fortunately, we were referred by a friend. They knew a trademark attorney because, of course, a nonprofit, especially an early stage nonprofit, doesn't have a whole lot of money to work with. So we needed somebody pretty much almost pro bono, let's say. It was pretty close. So they helped us kind of protect our basic information. And now we're so happy that we've been doing that over the years, because we're constantly adding, like as we add programs that we actually feel like we're going to keep. You want to protect the name because somebody else is going to come in and not model, but they're going to actually take it and just use it exactly. We've already had to send a few things out telling me, hey, look, we own that. You can't use that, which is a good feeling, because now you feel like, at least we've slowed the tide against ourselves, so to speak, as far as protecting our own property and our intellectual property, right? So
Well, that's the best you can do. You can only
Yeah.
slow the tide. I mean, people are
Right.
going to copy you anyways. And
Right.
I give the example of, street corners. You see people selling Nike shirts,
Right. Right.
etc. Nike's not going to go after that street corner necessarily because it's not profitable enough to do so. But if it is on a larger scale, the more successful you are,
Right.
yeah, the more targets you have, and people want to copy success.
Yeah, and I think part of ours was we didn't want people confused because if somebody goes
Right.
out using the same names, same terminology, but their quality is not the same as ours, sort of like the Nike thing, right? If you're doing knockoffs, so probably that shirt's not as nice as the original.
Right.
If we're doing programming or we're providing services, and somebody else goes out and has a name that's the same, you're like, wait a second, that's not the same service, and then it dilutes our value because then they come back to us and say, well, we know somebody that did that, but it wasn't actually us, and they didn't like it. You're like, wait a second, that wasn't us. So
And if the customers go to you to complain about a product or service that they went to another company
right.
with, yeah, that's a problematic situation as well, for sure. Yeah.
Right. Okay, so what were some of the early things that you got involved in as far as the different kind of patents and trademarks? What are some initially when you first started doing it? Because you said you were doing LLCs and companies, so was it mostly corporate stuff that you were doing? So what kind of things did you get involved in right away?
Right. Trademark, it falls under the U.S. Department of Commerce. So anything trademark related is always business related. And usually it's whatever companies want to protect and register their trademark. So in this process, most of our work, probably 95% of our work, was really trying to help the application reach registration with the U.S. Patent and Trademark Office. And I think you alluded to this, which is it's not required to have a trademark registration. It just helps you protect that brand and a slogan or whatever you have your trademark even better by having it registered with the U.S. Patent and Trademark Office. So the term is prosecuting it. And so what we would do is if there's an issue with an application, then we would help prosecute it to registration. Now, there are some cases, if somebody wanted to file a trademark application for Nike Reebok, USPTO will take their money and you'll pay the filing fees, but they're going to say, no, you can't, you won't be able to register that trademark because it's just likelihood of confusion with existing trademark registration. So we kind of tell people that as well. We get clients that would tell, or prospects we tell them, sorry, there's nothing we can do. This is unfortunately a waste of money. You got to start all over with something else.
So let's kind of walk through the process a little bit because I hope I get the name right. I remember Test, I think is the name of it, right? You go into the system and you can do a nice search. So if I say, if we want to trademark, in our case, we actually trademarked it AIR, AIR in our area. So
nice.
Just for us, even though there's the Jordan Nike Air, we have Air for mental health. So we were able to get that registered. So I tell my friends, I go, you got to be nice to me because if you want to breathe, we own the air, so you better be nice.
Right. And then you tell them you want gratuities for every time they say
exactly.
Air,
but
that air, right?
That was a tough one. That took a while because it's such a small, it's such a generic word, so to speak. But there's lots of things. So whenever we felt like there was something that was going to be an ongoing piece of our organization, we said, hey, we're using this all the time. And so we better go check it. So that's the first thing we did. I learned that you can go on that system. So kind of walk us through, if you would, when somebody might consider an item they might want to trademark, and then what steps should they take to see if maybe it's not already, like who's out there in the different categories. You want to walk through that little bit of a process because I was fascinated to find out all these different registrations you can do, which I found very interesting.
Yeah, absolutely. I'd be happy to go through the process.
Yeah.
The test system that you're used to, USPTO did update it, so it's no longer called test anymore. There's a brand new system. Arguably, people don't like it, but it is. What it is.
All right, that's the one I'm used to. All right,
it's a new So I would do that. I would go to the U.S. Patent and Trademark Office website first. So uspto.gov.
Okay.
Go under the trademark section, and there is a trademark search. Now it's not a refined search and it's not a comprehensive search, but it's going to give you a good idea of whether or not that name's already taken. That's really what you want to start off with. From there, if you do, there's ways to narrow the funnel even further. So you have a more precise search. That will take some time to play around with. But once you find a name that you think is relatively not used or abandoned, that's a good time to probably talk to a trademark attorney or an expert in the area, because that's not enough. Just because the trademark's not registered in your class is not significant. Trademark classifications, there's about 45 of them. And so when you file an application, it always has to be associated with some sort of goods or services. There's this wrong, I guess, conception that people think that once I file a trademark name, I own it for everything. And you don't. You only register it for the specific goods or services that you're offering.
Right.
In your case here, you're offering a radio broadcast program, and that's what we would file your trademark application
Right.
under. But if you want to expand that to clothing and etc., or mugs, then we could possibly do that. It really depends on how strongly you want to keep that trademark into the different categories. So
Right.
once you determine the trademark, whether it's cleared, and what classifications that you want to file it under, that's when, and then you also have to provide proof of use. So you don't have to provide proof of use when you start the trademark application,
Right.
but before you get it registered, a proof of use you have to provide proof of use. So in other words, USPTO will not grant your registration unless the trademark is actually in use in commerce. And that applies to everyone. So when prospects come to me and say, I want to just reserve it, there's no reserving. It's not like a domain name registration where you could just hold on to it and park it. You actually have to have it in use in commerce before it is actually registrable. And the USPTO will wait for that. There is a time limit on how long you can wait. It's 3 years after they ask for it, but you do have to provide proof of use. Some industries, I noted this in one of my videos, some industries will take a very long time. Royal Caribbean's icon of the seas. Shipbuilding is not it's not a 3-year endeavor.
Takes a little while.
It takes longer than exactly. So
Right.
so they kind of ran out of their extension, but they refiled it again because they had no choice. It wasn't in use in commerce. So by that time, when it was finally in use in commerce, they were able to provide the statement of use. And so that you just be aware of that you have to have something in use in commerce. If it's not in use in commerce, or you don't think it's going to be ready within 3 years, wait on it. It's not a good time to file a trademark application until you have something ready.
Excellent. We're going to take a quick break. You're listening to Master Your Finances. All right. You're back to Master Your Finances. I'm here with JJ Lee talking about a trademark. So you said you wanted to wait if you didn't think you'd be able to use the trademark right away because it has to be in use, which is something we kind of found out too, is because we had like programming we were thinking about putting together that we want to make sure we protected. And I just remember it's kind of a little bit of a dance. Like we're still developing the program and we want to protect it, but we haven't actually started doing it yet because it's not done. So we would kind of, I forget exactly what we did, but they would always tell us, you got to show us proof that you're actually using. So as soon as we actually implement it, we would give them all the brochures, the flyers, the dates, whatever we were doing to prove like when we actually implemented something. Right. And then that would get added to the filings. This is quite a little process. I don't know, to do it correctly, I think, people can do this on their own. This is one of those things where I'm like, you don't want to be your own lawyer, so to speak, in this, because there are a lot of nuances on this one. And if you don't word these applications right, because they're going to give you what you're asking for, and if you don't actually know what you need, do you want to talk about that a little bit? Because I know that was a big part of our process, was actually defining which of those categories we needed to be in and why we had to be in each one. Right. And do you want to maybe use an example, or I can tell you what we did if you want, but
well, let me start with example. Well, let me explain the premise of it, and then you could give your example. But the USPTO will not allow you to make material alterations to the word itself. So you have to be, or the word or drawing itself. So you have to be pretty sure. And we've seen applications, prospects of drawings on napkins, and they submitting that, not realizing it has to match exactly like the drawing on the napkin. And of course, they didn't complete the registration because it wasn't the final result. They were just hoping that concept would be preserved. But the USPTO is very, very literal and very strict. So in your trademark application, if your words have a period or a space and it's missing that in your specimens, that is an issue. Right. The USPTO will not accept the specimens or the drawing if it doesn't match together. And so that's how literal they are. And in the past, they used to be a little bit more, let's say, compassionate with some of the applicants, where they say, okay, it looks like you're trying to combine a couple of trademark applications together. And I've seen iterations of that, different fonts, in an almost stacked version of it. I want this. But the USPTO nowadays is going to say, well, your specimens doesn't match the literal line by line items of your different variation, and they're going to hold you to that. And that's a specimen they're going to be looking for. And when I talk to the prospects, I'm like, are you ever going to have a product or service or goods where you're going to list all these 3 different fonts together? And they say inevitably no. Right. And I said, we can't do anything for you. You have to start all over. because USPTO is going to be very literal about how you file your application. So you touched on something that's very important, is that once you file that application, there's very few things that you can alter to adjust anything. And so I bet you say you have an example of that.
Well, yeah, that one, I was thinking about something different, the categories, but I do have an example of what you just said. Is when I'll use my example of AIR. When we registered AIR, it's capital AIR, okay? And it stands for Attitudes in Reverse, which is mental health is like air. Just because you don't see it doesn't mean it doesn't exist. So our name is Attitudes in Reverse. Our DBA is Attitudes in Reverse, but we often consolidate it down to AIR. And one of the things we ran into is whenever we would like somebody to write an article about us, they would write A period, dot period, R period. And we would have to constantly tell them, no. And this is before we were filed. We were like, we want to use AIR, no periods, because we want to be able to protect that at some point, right? This was just us thinking ahead a little bit, right? We had a little, and so we did. That's not how we want to be known. And I would say probably 8 out of 10 times people would put the periods, because technically that's correct. It's abbreviation for a thing, but we're like, no. This is another DBA of our organization, because that's what most people tell us. That's how they call us. And we eventually got it, of course, but it was a hard time. We had to go find all these samples and all these articles that people, like a large paper, would write something about us, even though we would tell them. The editor would come in and put the darn periods in there, right? The editorial staff would add them back in, and that drive us crazy, because we're like, no, that's not the term that we're using. So,
and that's not your brand. That's
not the brand. Exactly.
You're representing your brand. That's exactly right. But to go to the category part, you're absolutely right. We've seen too many applications where people wanted to produce a clothing line, but there's this one classification where it's a printing service that offers printing on clothing, mugs, and pens, etc. And people mistakenly think, okay, well, I'm printing stuff on my clothes. That's the category that I want to file it on there. It's a service class. Now, that's a service that's appropriate for businesses like Vistaprint, where they're actually printing other people's products, other people's brands on different products. It's not appropriate if you want to offer your own clothing line. So inevitably, the USPTO is going to say, where's the service? We need proof that you're offering this service. And when prospects come to us regarding that, I've only had one time out of probably 50 or 60 when I question them, they're like, yeah, we are doing printing services. But everybody else, we had to tell them, sorry, we can't change the category. You have to start all over.
Right. And I know in our case, and I'm not going to get the categories right, but we would, like AIR would be like, I don't know the categories by heart, but I think we ended up with either 3 or 4 different categories based on mental health, education. I think we do, I don't know, some kind of thing like concerts, and I don't know. There were like 3 or 4, and I think AIR we got 3 out of the 4. Like one we ended up dropping because it was too close to something else that was out there, and so we couldn't get it. But that was fine with us because it was enough for us to need to do what we needed to do. Honestly, so.
Good job.
You kind of go for everything, that you think are within your realm, right? And if you get 75-80% of it, you can usually work around it, right? You're not going to infringe on the other person, and that was the case in our case. So, a website, that's what it was. Websites, I think, was one of them we got, because our actual URL is air.ngo. So that was part of what we could lock down, because that was actually something we've been using for years.
Okay.
So
perfect.
But anyway, so I mean, I guess that's the thing, that the categories are really, really important. And it's not, as you point out early in the program, it's not like you just say, I want this name or this, because there's different slices of the world out there, and you can register it in one area, and somebody else could register the exact same name and be a totally different product or service. Right. And you're not going to overlap because you don't do the same things.
Right.
That's kind of their point of view.
The example of that is Delta Faucets, Delta Airlines,
there you go,
and Delta Dental. That's a classic example because Delta is in all 3 of them. Apple Records, Apple Computers, Apple Employment.
Okay. All right, so there you go.
You have all 3 of those, right? You can tell I've been doing this for a while.
I guess you have, absolutely. So if I guess let's get to the point where like somebody has a business. So what businesses should actually seriously think about? Because they have, isn't there? And we were talking about this before the show. The GM here was talking about how they, somebody was coming to them, but they had, and I forget what he called it, but basically. Common, I'll call it common use, right? They've been using their information for years and years and years. And then somebody else went in and tried and trademarked something. But in their case, it's not really the same anyway, so it doesn't matter. But But if I've been using a name or a term or whatever for years and years and years and years, but I never protected it as far as a trademark goes, do you want to tell us like what maybe inherent protections I might have and why you may or may not need to go through the registration process if you've been kind of doing something for a long period of time using certain terms or certain names or whatever the case may be? You want to kind of walk us through that?
Absolutely, yeah, absolutely. So that's referred to as common law trademark rights.
Okay.
And it's like a barber or a restaurant, a cafe that's been in business for a long time, maybe 20, 25 years, or any amount of time. Well, let me back up a little bit. The trademark is yours once you start using it in commerce. The question is who has greater rights? Is it you or the other person? Depends on the usage. And so if you've been using it for a long time, let's, for example, this barber or this cafe, let's say they've been in business for 20 years, there is, even if somebody registers that same trademark with the U.S. Patent and Trademark Office, and it's been done after the first usage of your common law rights, they can't tell you to stop using it. But what happens is there's an imaginary kind of fence around your area of influence. So if you've been working in one state or with this one county, and they have this trademark registered for the rest of the country, which is what a U.S. Patent and Trademark Office, federal USPTO trademark registration offers, you can't expand beyond that. That's kind of where the conflicts and the friction happens, is that if that barber decides, I'm doing pretty well, let me go to this other state and open up. If there's a trademark application that was filed and registered in between that time that you started yours and you opened up a new location, that's where the friction will happen. But for the most part, even if somebody registers a trademark with the U.S. Patent and Trademark Office, they cannot tell you to stop using it because you have prior use and you have priority. In the U.S., first usage dominates. That's what wins the day, is whether or not you use the trademark first, and in common law rights, where.
Right. So at minimum, take date stamped photos of what you're doing. somehow document when you start using something, I guess is what I'm saying, right? Because you have to go back and actually, and that's part of what we had to do. We started like these things we've been using for years. Okay, that was the first question they asked. Well, when was the first time you actually used it? It was say, well, we think it was, and I remember we used like the Wayback Machine for some of our stuff. Yes. We're like, yeah, well, I remember we published a flyer somewhere, and we were like searching, and we were getting snapshots to go, okay, we can date it at least to March of like whatever, 2013. Right. There's a picture of it online, right? That kind of stuff. I remember doing that. But I guess if somebody's using something, even if it's like your barber shop, right? At least document that you've been doing it, right? Because if you can never show that you ever used it in any way, shape, or form, then you may have an issue proving when you started, right? If you have to have something, it's always a good idea, I guess, to keep some kind of record, even if it's an informal record of what you're using.
Right. And to clarify that, I appreciate you brought up, it's a great segue to this next thing, which is just because you filed a LLC or corporation or DBA, that's not sufficient for trademark law in terms of first usage in commerce. It means nothing at all. The best example I could give you is a hotel chain that had a hotel filed the application. They could not provide proof of use, even though they built the whole building, wired it, plumbing, all of that, until they can open the doors for the first client to come in. That's the first use in commerce, not the building, not the plumbing, not everything else. And people sometimes say, well, I go to trade shows and I do this. Well, that's not offering it to the public. You have to actually offer your services and goods. It has to be consumable by the public. And that's when that's the first date of use in commerce.
Awesome. We're going to take another quick break. You're listening to Master Your Finances. Hi, Kurt Baker. I'm here with JJ Lee. We're talking about trademark law, which is awesome because it's kind of that part of that value of your company, and you kind of protect your brand and your name and things like that, which we've used it a lot in our nonprofit. We've been very happy that we've done it because we have been able to protect ourselves because we're kind of cutting edge, especially going out and doing things that are new and innovative and things like that. Eventually, somebody's going to copy you, and they may try to take those pieces that actually identify you. In that case, there's a problem, right, for you, because now they could dilute your product or service and actually really cause you some serious financial harm. So I guess one thing, let's talk about a little bit. So some people work like just in one state. So you got the federal, right? And then you've got international, right? So do you want to talk a little bit about like the different levels, if I'm a company that's just working in one state, and if I'm a company that wants to make sure I can go across the country, or let's say I decide I'm going to go international, what kind of thing, how should I think about that as far as trademark and protecting the brand and things like that.
Right. For trademark registration, especially if you're protecting it nationwide. So it benefits you, especially if you are planning on selling your services either outside of your geographic area or online. And that's really an opportunity to protect your brand across the whole nation. If you're very limited by physical presence, and you're only at one location, it may not make sense to register a trademark unless, like let's say you're a very popular barber shop, the example we just gave.
Right.
What if you're selling clothing with your barber logo? That's a great idea too, especially if you're expanding onto other services or goods. That's still an opportunity for you to register a trademark, because even though you're offering the barber service in one location, doesn't mean you can't sell other paraphernalia or other products outside of your localized area. And then you can also expand that across to other countries as well. U.S. is part of the Madrid Protocol, which reciprocates protection across many of the countries, almost all the countries out there. There's some very limited countries that we can't reciprocate with, but there's opportunities that once your trademark's registered, or even before that, you can actually extend your protection to other countries. The benefit of that, especially when you do it through the U.S. WIPO system, is that a lot of these countries don't require proof of use in those other countries, although some do. But there's an opportunity to extend and expand your protection to either Europe, the UK, Japan, etc. if you want to extend your protection. Now, it's not required, and it does tend to get pretty expensive. So those countries that you're actually planning on doing business in, it makes sense to extend it there.
Yeah, that's great. Yeah, so you want to protect it. So, so what other situation have you seen where somebody maybe had a challenge, right? So I've got a trademark. So how do you handle when you start to see somebody infringing, or how do you monitor to make sure somebody's not infringing? Those are kind of two separate but similar questions. So once I'm trademarked, next thing I want to do is make sure nobody uses it, because if they start using it, I want to make sure that I come after them sooner rather than later, right? And give them a cease and desist, so to speak, right? So kind of walk us through that process where, like, okay, one, how do I monitor to make sure that that's not going on? Because I'm doing my job. I'm not necessarily seeing the world all day long and paying attention to my trademark. And then if I do see something, when should I respond, or how should I respond, and things like that? What are your thoughts about that?
So monitoring it depends how much monitoring you want to do. You could be overly inclusive or be very selective. There are some monitoring. If you're monitoring just the U.S. Patent and Trademark Office, that's probably the most efficient way, but doesn't mean it's comprehensive. The people filing a trademark application with the U.S. Patent and Trademark Office, they do have a couple of barriers to having their trademark registered, which is, first of all, you have your trademark registered first. That's the other benefit of that too. If your trademark's already registered, somebody else tries to file an application very similar to yours, the USPTO will warn them and prevent that application from reaching registration unless they are able to distinguish or differentiate them from the others. Now, it's not 100% foolproof situation, so you do want a monitoring service, either a service from either a law firm. We are starting to offer that service probably at the end of May, beginning of June, or you could just a free way to do it is just do Google Alerts. To just do
that's exactly what I do.
Yeah, do you do that? Have you done that?
I do it. I've done it daily. Google Alerts, they come up, but it can be overwhelming. I have to be honest with you.
It's overwhelming though.
It can be overwhelming.
But that's a cheap way to do it, because you don't have to pay anybody to do it. Google just alerts all these different instances of it. But you can also monitor the U.S. Patent and Trademark Office to put something to put your words in there, and just monitor it every month, because you do have an opportunity to oppose a registration. And it does take about 6 to 8 months before the USPTO examining attorney reviews it. So let's say you forgot to do it 1 month, but at least in month 2 or whatever, you can actually look it up and see whether or not somebody else has filed something similar. You have an opportunity to file a letter of protest. That's something that you can do early on before the USPTO examining attorney looks at it. What that does is alerts the commissioner, the director of the U.S. Patent and Trademark Office. They'll send it to the examining attorney saying, this anonymous letter has come from somebody else. and they're concerned about this trademark application because of these reasons. And in your letter of protest, you would dictate all the reasons why it could cause likelihood of confusion. Now, the examining attorney could choose to ignore all of that and just go based on their own opinion, and but they could also use that as well. So that's one stage. The second stage is once it gets to publication for opposition, you have an opportunity to oppose your trademark registration. But going back to your trademark application, that's also the other part that's very helpful, which is it's vetted. It's vetted not only by the USPTO seeing whether or not your application is in conflict with somebody else's, but then also a third party can choose to oppose it. And if they choose to oppose it, that's a lot cheaper than going to litigation afterwards. And you know upfront whether or not this is you should stay away from this, or this is relatively clear for usage.
Yeah, fascinating. So I have a different question. Like if you trademark something, in our case, we trademarked "Start the Conversation." Okay, and we actually had this happen to us where somebody else came in and argued that was too common of a term, even though we have a registered trademark for that for mental health, and we were the first ones to ever use it for sure. Somebody else came in and incorporated that into a longer phrase, and they actually won that argument. So my question would be, and this is what I said, well, but that means they have to use the whole term, right? If they say, start the conversation A, B, C, D, let's say, right? And they go, yep, that's approved. What if they go on and they just use our little slice instead of using the full name? I think that's a violation, right? If they just use what we've already registered, they have to use the whole trademarked phrase, correct? That's my interpretation. That's what would make sense to me.
Right. So, Kurt, I'm a little shy of getting.
Don't give me legal advice. Let's term it this way: if you have a short phrase and somebody tacks on a long phrase,
yes.
Don't they have to use the whole thing? If they're, are you supposed to use the whole thing that's trademarked?
Well,
not half the car. Not half the car.
Let's go with that scenario. So the question is,
I didn't want to I didn't mean to trap you. Sorry about that.
No. Don't worry. So the question is, have they abandoned the other trademark? And so in that instance, we would go and look to see whether or not there's an abandonment by the trademark by the trademark owner on whether or not they're not using the whole phrase. Because if they stop using it for 3 years or longer, that's prima facie abandonment. In other words, they have to show that they'd be using the whole phrase because that's what's registered. If they don't, then you can come in and try to cancel their mark based on abandonment.
Yeah. And you bring up another point because, I think I may have the timing wrong. I believe it's every 5 years. Don't you have to go back and recertify it? Otherwise, you're. Explain that, because once you trademark, that's not the end of it.
And so
walk through that if you wouldn't mind.
Yes. So you do have to maintain your trademark registration, and let me start with what's normal. Almost all countries, it's 10 years. In the US, is registration renewal every 10 years as well. However, they added a 5-year mark because they've noticed there's a lot of deadwood out there. The businesses don't last for 10 years. And so there's a lot of trademarks that have been registered for way too long. Maybe they went out of business in year 1. You don't want to hold on and kind of lock up that trademark for 9 years because they're no longer using it. So they have a Section 8 filing, which is an affidavit stating, I'm still using this mark in commerce. Here's my proof. And that's between the 5th and 6th year anniversary of your trademark registration. So so it's hard to explain that succinctly with our clients. We just say you have a renewal after the 5-year, after the 10-year, and after the 10-year, it's always every.
I remember it was really simple. It wasn't like it was not a heavy lift, but I looked at it, I go, oh God, the government wants me to go do something.
Yes, exactly.
I don't remember it taking me very long once I started actually going through the process.
Right.
That's all I remember, but
that part
it wasn't too scary.
Using a convert, it's not too scary, right? You've already had your trademark registered. You've already had it reviewed by USPTO examining attorney. It's just now maintaining the usage of. As long as you're continually using it in commerce, you should be fine.
Okay. Awesome. Okay. So what new and interesting things are you seeing going on out there right now? Because we have a lot of like AI stuff going on and a lot of anything, because I know they talk about, well, if a computer is building this and you make it and you do that, can you talk to a little bit to this kind of next generation of quote creativity, right? Blended with some human aspect, I guess, is what it's supposed to happen. So what's going on with that as far as trademarks go?
So trademarks are not really affected by that, but I will give you a weird, funny thing. So Amazon requires trademark registrations in order to access their top tier marketing platform. And in order to market to others through their top tier, you have to actually have a trademark register. So what we're seeing, it's the craziest thing. So you see a lot of foreign companies actually just typing random letters on the keyboards and trying to get those registered just for that privilege. They don't care.
Even though it has nothing to do with
says.
their business?
It's nothing to do with their business. They're just trying to get that top tier. So that's one of the funniest things I've seen. I'm like, the most common terms that are, the QWERTY, QUR, the keyboard terms, they're just typing random, yeah, the QWERTY. They're just typing random things in there just to get a trademark registered. And they know no American will care about whether these random letters are they make sense or not, or pronounce even you're able to pronounce them. But the whole point for them is just to get a trademark registered so they can access Amazon's top tier platform. Now we're also seeing this from Alibaba and Walmart as well. So you're going to see an increased number of trademark registrations because Amazon's saying we're not going to deal with this. You go through this platform and have it registered, and then from there, as long as it's registered, then we'll consider you legit.
Awesome. We're going to take another quick break. You're listening to Master Your Finances. Welcome back. You're listening to Master Your Finances. I'm here with JJ Lee, and we're talking about trademarks. Nationally is the most common one, to protect it nationally, which is awesome. It gives you it gives us a lot of peace of mind, so to speak, to know that once we have at least a little bit of protection, we can kind of slow that tide against us. What do you do about all of the nefarious players out there, which seem to be growing and the people that are creating things that are not legit? So how do you protect against those types of people?
It's getting more and more nefarious, and it's getting harder to just discriminate between whether something's legit or not. The USPTO will typically send email notifications and nothing else, and that becomes problematic, especially when you file an application. It's public information, so they have access to your email, your phone number, and your address. So just be aware of that. The best way to avoid this is probably have an attorney or representative put their information on there. Mm-hmm. That way yours is not listed on there. So just note that if you have an email address, you will get email solicitations from them. Sometimes they spoof their numbers, their email address, to say they're from the USPTO. There are a lot of letters that come out. The USPTO, if you look it up on their website for trademark scams, there's a whole list. I would say probably almost 100 different companies sending out letters specifically saying you have to file this, or your renewal is coming up and you got to pay us now for these sort of things. So just be wary. There are ways to look for your trademarks to make sure it's legitimate, but even scammers are now calling our clients because they have their phone numbers listed on there. Right. They're saying they have to pay extra money. It's just really, it makes it much more difficult to do business legitimately because everyone else is suspicious of you, number one, and number two, even if you are doing things legitimately, they are being picked off or pawned off by scammers who are taking advantage of people and their fears about whether or not their trademark's up for renewal or has been abandoned. So just we post videos on this. We do have a weekly newsletter that we post. You can go to TM, that's TM for trademark, tmtelegram.com, and we offer weekly newsletters, trademark tips and tricks and news, including scams like this. It's just the more informed you are and the more vigilant you are, the better. Our clients typically contact us saying, is this legit? Right. We'll let them know whether or not it is.
Yeah, and I agree with that. I mean, scams in general are a big problem. I'm in the wealth management side of it. So anywhere there's money involved, people are going to kind of come after you. And there's a value in this where they can get some money from you. And as you point out, you can go back to the source, right? So I'm a big believer in if you're not 100% sure about an email, you go outside of the email system and just go search the source yourself directly, however you've saved it or found it. Call your attorney. Don't go back through the same system that solicited you, is what I always tell people, is pretend it wasn't there and say, okay, well, this is interesting. It's a trademark issue. Let me call JJ up and see what the heck the deal is. And he's like, I don't know what you're talking about. We didn't send you an email about that.
Right. So. We do. They do text us saying, is this you? And we're like, right. No, that's not. You can put on that spam. But if they do call you or email you, or especially calls, right, get their name. get their number, and they get their email address.
Oh, that's
If it's
awesome.
le if it's legit, then they have no issues. USPTO will have no issues for you calling them back. If it's not legit, they'll
Right.
hang up.
Yeah, that's a good point. That's a good point. Get their information. I'll call you right back. I'm busy. I can't
Yep.
talk right now.
Right.
Any excuse you can come up with. That's interesting. Um, so, do you ever have any things where maybe there's a dispute between like what I've registered and maybe what somebody else is registering? So, what do you do when you get involved in these little nuanced things? I remember. And this may be off the topic once. I remember, I think it was, this might be getting back to what we talked about before, but I think it was like a place down in Texas or something that had some little like shop, but then one of the big brands came down and they were like, they could keep it. Ultimately, they kept it because they had been there like forever, for decades and decades and decades. And so are there any tips about what I should do to make sure it's clear who I am as opposed to like who somebody else is? So there is no confusion about brands and things like that. Any ideas about that?
Just promote it more, I guess.
Okay.
Make your public associate that phrase with you.
Right.
That's really the best you could do. You have to be proactive about keeping your brand protected in that regard. There was this one prospect that came to us. They they used to own the word hoodie as a registered
Oh,
trademark.
hoodie?
But yeah,
Wow.
hoodie,
That's
yeah,
awesome.
in clothing too.
Yeah.
And they allowed it to be canceled because they forgot to renew it.
Oh
And
my
they said, "Can I
goodness.
get it back?" I'm like, "It's too late. There's
Yeah.
there's nothing I or anyone could do to get that word back for you." But just be vigilant about your trademark.
Yeah.
Uh, it is a frustrating endeavor, but the more it is part of the price of success, I guess. That's the best way
Yeah.
I can put it. But there, you should put some time and budget in terms of enforcing your trademark because um, it's going to be it's a constant it's constant work. But know that in advance before you go ahead and proceed with it. It's not an invincible defense,
Right.
but it is a great shield and sword in terms of helping you move forward. So we've had situations where there are scammers that would copy domain names of their trademarks, and so without those mistypings or
Mm.
.net or .io, we can transfer that over. We've done that for our clients where if you have a registered trademark and they're just trying to copy your domain address, we can go through this mediation service to show them that they're not using it in good faith and that they're taking your brand and diluting it. And we can, if successful, we've transferred those over to our clients. So there are a lot of protections that you have. Just be aware that you have to be constantly vigilant and fight for them.
Yeah, you got to touch on something a little bit. Maybe we'll talk about it a little bit more. Is that how do you prevent your brand from becoming a common term,
Generic,
right?
yeah,
Generic term like the hoodie, right? Because hoodie was trademarked. I think Kleenex as an example is tissue.
right.
I mean, there's certain things that Xerox copier. I mean, these things that started becoming like generic because that's what everybody referred to them as. So, as a brand, how do I make sure that the world doesn't start using it? And it becomes a generic term, and then the argument's like, well, that's generic. I can use it however I want now, regardless of your trademark.
So it's enforcement. It's all about enforcement, and that's what I don't know if this is a true story. I don't know if it's urban legend, but they're about Coca-Cola going to fast food drive-throughs and asking for a drink, and if they reply, "Do you want a Coke?" You know how in
Right.
some parts of the country they
Soda,
refer to everything as
pop,
Coke or
Coke.
pop, yeah, Coke, right? And so they would enforce that if the employees would repeat it. And they weren't selling Coke; they were selling Pepsi, and they say, "Do you want Coke with that?" Then they would then send them cease and desist. So it's a matter of enforcing it, making sure that
Right.
people are using it in proper context. If they're using it in public, you want a letter to go out to them, the publicists to go out to those either newspaper, magazines, or any other publications saying you're using this in a generic fashion. This is a registered trademark. We're enforcing our trademark rights. And we want you to use it properly. This is the generic term. We want you to use the generic term and not refer to as Kleenex, for example.
Right.
It's facial tissue, right? That's what it is.
Tissue,
right?
yeah, exactly.
Yeah, exactly.
Tissue, see, you had to think about it, didn't you?
Yeah, I had to think about that too. The funny thing, I associate, people like, should I get a patent or trademark? I'm like, well, trademarks, if you make an association with your invention with that trademark, it gives you much more volume and much more help. the best example I give is the Swiffer. You know what the Swiffer is? It cleans
Yes,
up
I do.
dust, etc. Yeah, and there are so many copycats that made something very similar.
Right.
I just don't know what number two is. The number
Right.
two brand of Swiffer, I have no idea. So that's almost at the level of being generic because I don't know what else to call it. It's a dust picking up device.
Yeah, I don't know what the
but
name is because their ads were so good and it described
right,
it so
right.
well what it did.
And if I explain to you, yeah, I have a Swiffer, you know exactly what I'm talking about. So they're on they're gonna have to start enforcing it or identify a generic term to call that. Otherwise, people are just gonna refer
Oh,
to it as a
interesting. You have to
Swiffer.
identify a generic term. That's an interesting. I didn't really think about that. So
Mhm.
as opposed to Coke, you have to call it a soda. Or you have to call it a pop. Or you have to
Exactly.
call it a
Exactly.
right.
Exactly. Right.
Wow. So you touched on. You want to briefly describe the difference between a trademark and a patent because you kind
Yeah,
of touched on it a little bit because they are different.
they are different. They are
But
different.
so
So
explain the
trademarks,
difference between the two.
yeah, happy to. Trademarks is a brand protection. It's a protection of your brand name, Coca-Cola, the symbol, even the bottle of the Coke
Mm,
bottle. It's a trade dress. So if you see that silhouette from afar, you know it's Coca-Cola. So trademark will always associate. It's an identifier of goods and services. So if you look at a specific logo, name, word, even motion or smell, you know where it comes from. Whereas patent is a design for inventions. So your the iPhone itself, anything kind of mechanical, anything that's a a device or design, that's more in the patent realm, and we don't deal much with that.
right.
But that's the difference. But those go hand in hand with each other because you could create a device and you could create a certain process, just like the Swiffer is probably there's a patent to that, but
Right.
doesn't mean that people will identify it by the patent number. They identify it by the trademark.
Right. And like your iPhone example, I mean, there's the iPhone, the name, and then
Right?
there's the iPhone, the actual mechanical device. So I'm sure there's
Exactly.
lots and lots of patents in there to protect the actual device itself. But we all know what the iPhone is. So,
Right.
so
Exactly.
that,
Exactly.
that's awesome. So any final tips or tricks or things that we should be aware of out there in the trademark world? Advice to people out there that maybe should be thinking about trademarking things that maybe aren't doing it and they might be
Right.
a little more open than they thought?
Well, I guess just evaluate your business, evaluate what terms and phrases that you use constantly that you don't want somebody else to use or that you want protected. Are there certain phrases that you use very frequently or that people know you as? Would it be problematic if somebody in a different state used the same phrase as well or same term? And this doesn't apply to just your name of the company. It applies to how you're using a service or goods or how you associate in a certain service or goods. So I say kind of do an internal audit to see whether or not there are some things that you would not want somebody else to take or also use as well.
Excellent. Thank you, JJ. It's been very helpful. You're listening to Master Your Finances.